seated. We'll hear argument in case number 240759, American Pearl Group and others versus National Payment Systems.
Mr. Catanzarite will present argument for appellants. Appellants have reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. We're here from a certified question from the Fifth Circuit Court of Appeals. We cite the precise question in our brief. It's a narrow question. In fact, I can read the second part of the question, which states the issue. If a loan in question provides for periodic principal payments during the loan term, does computing the maximum allowed interest rate, quote, by amortizing or spreading using the actuarial method, end quote, require the court to use to base its interest calculation on the declining balance for each payment period rather than the total principal amount of the loan proceeds, end of question? The answer is a resounding yes. The Texas statutes, in fact, are precise on the issue. Texas Finance Code 306.004A reads, to determine whether a commercial loan is usurious, the interest rate is computed by amortizing or spreading using the actuarial method during the stated term of the loan, all interest at any time contracted for, charged, or received in connection with the loan. There's a lot of cases that touch upon issues of what is usurious. Cases are tried in the trial court, go to the Court of Appeals. This court has addressed it, both the Tanner decision and the Neville's decision has addressed the question of usury. It's not an unusual question to deal with. What's unusual is that we have a statute that says with precision, use the actuarial method. The actuarial method is well recognized. Every state recognizes it as a method. It's you can get it on your cell phone. You can look it up. What is actuarial method? And it is, as Black's law defines, it means the determining the amount of interest on a loan by using the loan's annual percentage rate to separately calculate the finance charge for each payment period after crediting each payment, which is credited first to interest and then to principal.
So does the payment schedule with this specific document depart from that? Because it has specific amounts of principal and interest for each payment. So it seems like that's not necessarily the same as this default rule that everything gets credited to interest and then the rest to principal.
Right, and the answer to that question is to harken back to Mr. Sinclair's Frank Sinclair's article in 1979, which talks about, quote, the spreading of interest under the actuarial method, 10 St. Mary's Law Review 1979. And the, shall we say, the gaming of the system to avoid a usury charge is recited in advance back in 1979 by Mr. St. Clair, who says, quote, the question of multiple interpretations of a statute, however, can largely be resolved by elimination of those methods that allow a lender to circumvent the usury laws through a disguised form of the transaction. It is the contention of the author that of these possible methods only, the actuarial method prevents the possibility of evasion of the usury laws. Now you're spot on. I have it. They allocated principal and interest. They had a denomination of amounts in their schedule, their loan schedule.
And so your contention is that we disregard that and calculate it like the statute says.
Well, I think, yeah, you calculate it like the statute. The total, what does the statute say? The statute says take the total payment, apply it first to interest, the balance to principal, which results, since you're paying more than the interest being accrued, in a declining balance of the principal over the term of the loan, the 42 months, 3.5 years. That's not what the district court did. What the district court did was no semblance of use of the actuarial method. In fact, it's quite obvious that he ignored the actuarial method because he ignored any reduction of principal, which was obvious by the very schedule to which you referred, Your Honor. In other words, is principal being paid or not? Neville's dealt with interest-only loan. That's simple. Anyone can figure that out.
Can I ask you an antecedent question? Footnote 1 of your friend's brief says that the agreements say that Oregon law should be applied, and the district court, as I read the footnote, I didn't go back and read the district court's order directly on this point, just read the briefs, said that, well, Oregon law would require this, but even if Texas law applied, Texas law would reach the same result. Am I understanding that correctly, what happened?
That's what the district court said, yes.
So if Oregon law applied, the district court held that we would just do the simple calculation that ignores the statutory method.
Well, we didn't get to the issue as to whether or not Oregon law would apply.
So we don't have a holding as to which law actually applies.
We do not.
And so if we resolve this Texas law question, it could well turn out that Oregon law applies, which makes me wonder, are we going to resolve the case by answering the question?
I think you will resolve the case by answering the question, because the Constitution of Texas, in fact, makes it public policy with respect to a charge of usurious interest in the state of Texas. The transaction.
So, well, you're arguing that Texas law should apply then, is
yes,
what you're saying?
yes, sir.
But that's not really our call. That's for the Fifth Circuit and the district court, I guess, and the federal district court to decide that, and they haven't decided it yet. But we're being asked this Texas law question, which matters only because, as I read it, the district court is saying, well, luckily both state laws reach the same result, so I don't have to make this decision. Now, if we were to go your way, now that just sets up the question of which state law applies. Is that enough for us to resolve a certified question? It might not really determine anything.
Well, no, I think it is more than enough to resolve the question, because once that sets up the question, then the question becomes, is the loan usurious under Texas law? The answer is resounding yes, because it's tacitly admitted by my colleagues, by the opposition, that the interest rate, if you count principal in the loan, the interest rate is 34.5%, whereas the commercial loan limitation.
Yeah, I don't want to beat the horse anymore. This is the last time I'll beat it, I promise. But if Texas law doesn't apply, what difference does it make if under Texas law it would be usurious or not?
Well, I can only answer as I did, that we believe Texas law applies to this transaction.
Could I beat the dead horse a little bit more, counsel? So Article 5, Section 3-C of the Texas Constitution is what I think in 1985 gave this court jurisdiction to answer certified questions, and it also, the Constitution called on us to make rules. And in Texas Rule of Appellate Procedure 58.1, it says that this court may answer questions of law certified to it by any federal appellate court if the certifying court is presented with determinative questions of Texas law having no controlling Supreme Court precedent. So in addition to the choice of law question about Oregon, if I understand correctly, your position is that the loan is not only usurious because of the way that the math was done, but also because of the option agreement. Is that right?
Yes, and that's a question also returned by the Fifth Circuit to the district court to determine the question of fact as to whether or not what we call the bargain discounted option exercise constitutes additional interest, which makes the interest rate in excess of 50-60%.
And so would this court's answer to the question of how Section 306.004 is interpreted, would it even matter if you're right about the option agreement?
Well, I think it matters for plaintiff to achieve summary adjudication on that first claim, which is, the first claim is it facially usurious pursuant to the schedule that's been identified? If facially usurious, plaintiff wins round one, count one, then we try the second question of whether or not it constitutes the option bargain option constitutes additionally usurious interest, attaching all manner of penalties associated with it.
Was the calculation that the district court used in this case spreading as opposed to taking into consideration the declining principal balance, was that essential to the district court's judgment in denying your claim?
Yes. In other words, I can give you the math. The district court took 28% times the principal amount.
It was essential to the judgment. So if we're talking like in terms of collateral estoppel, one of the things you look at is whether a particular finding is essential to the judgment. And here, the calculation was essential to the district court's judgment in concluding that there was no usury.
Yes.
And on the subject of doing the math, I apologize if I missed it in your brief. Does your brief go through how you contend the district court should have done the math here? I know that you end up with an answer that's somewhere in the $200,000 range, but I know that from reading the Fifth Circuit's opinion. Is there anything in the papers that are in front of this court that show how you contend the statute is supposed to work?
You know, regrettably, no. We attached a schedule that calculated the usurious interest compared to the schedule. It never became a matter of dispute that our calculation was not accurate if you counted the principal payments over the 3.5 years in making the calculation to determine what was usurious or not. So no, regrettably, there's a schedule that appears, which would be our calculation, and I have that site. I can get it and give it to you in the record after I figure out how to find it on here.
Thank you.
But yes, we see this as a very simple, straightforward question. Texas statutes, this statute does not lend itself to any ambiguity, does not lend itself to multiple interpretations. It's crystal clear how to make the calculation. Usury, the court should embrace that usury calculation should be made with precision. Fortunately, today we have all manner of easy methods, Excel spreadsheets and so forth, to calculate usury with precision. We should not hearken to the rules of...
Counsel, if I can just ask, so I think what's crystal clear is that the statute says you have to use the actuarial method, right? Well, I don't think anyone disagrees with that. It's right there in the language of the statute. Is it correct to characterize your position or your interpretation as, by referring to the actuarial method, it means amortization, not spreading?
Well, I think, you know, the wording spreading and amortization appears in a whole host of statutory references, including along the way spreading or amortizing in equal parts. Amortization is something, we all get an amortization schedule, not a spreading schedule. I would not dance on the head of trying to say spreading means something entirely different. I think amortization is clear and unambiguous.
I mean, it just seems to me that clearly the statute uses, I don't think anyone disagrees, you got to use the actuarial method. The question is, what does that mean? And how do you respond to the argument that, well, it can mean amortizing or spreading? Because the statute itself says so.
The statute, yes, the statute reads amortizing or spreading. They're one and the same, amortizing or spreading, by using the actuarial method. The actuarial method is defined in a whole host of statutes, including the Truth in Lending Act, including several provisions.
So it's not your position that the statute doesn't allow calculation based on spreading. It's your position that the district court misconstrued the concept of spreading as used in this statute.
I don't know that the district court counted at all well, I know they don't. The district court did not count at all any principal reductions. Therefore, it didn't spread anything. It just took total maximized interest, took the scheduled interest, and said one is less than the other.
Well, it basically spread the entire interest, it spread the total interest over the entire term of the loan.
The calculation the district court did to determine the calculation pursuant to 306.04A, 004A, was a simplistic calculation of multiplying 28% times principal over the 3.5-year term of the loan, taking that total, looking at a schedule, which I point out, the schedule had principal reduction throughout the 3.5 years, and said, see, that number is less than your number scheduled, therefore you lose. That can't be the case because that schedule included principal reductions over the entire 3.5 years.
Your position is that the actuarial method means that interest accrues only on the outstanding amount of the loan. So if part of the loan is repaid, you're not paying interest on that. You're continuing to pay interest on what is the outstanding amount of the loan. And over the term of this loan, the principal balance declined, so the outstanding amount of interest that was accruing also declined and should have been taken into consideration in determining the maximum allowable interest rate.
To use a percentage, 100% correct, yes.
So, and the idea is in 1990, the ceiling for usurious interest increased. And in connection with that, they said, yes, but you're not going to be allowed to charge interest on a part of the loan that's no longer outstanding. So if you happen to repay the entire principal balance the very next day, you can't continue to accrue interest for the remaining term of the loan.
That's correct, and that's the gamesmanship that Sinclair identified, is that you could manipulate, and you manipulate it by the large principal payments on the loan over the course of the term, yes. And it could be gamed otherwise, yes. And
Any further questions? Thank you, Mr. Catanzarite. We'll hear from the appellee.
May it please the court, Mr. Kessler will present argument for the appellee.
Mr. Chief Justice, may it please the court. The court's agreement between the appellants and the appellees is the contention by appellants that Texas requires you to use the actuarial method and just those 2 or 3 words. But what Texas law, what the legislature actually requires is amortizing or spreading using the actuarial method. And it comes down to a disagreement with respect to what spreading using the actuarial method actually means. The great majority of my friend's brief focuses just on the words actuarial method as it's used in Guam or Iowa or Ohio or what have you. But that is not Texas law. Texas law in 1997 and 1999 codified this court's decision from 1937 that the way of determining whether interest is usurious is to spread using the actuarial method.
So is your contention that a court considering this has to do 2 calculations and they'll be different in most cases? In one calculation is amortizing using the actuarial method and a different one is spreading using the actuarial method?
And I struggle with that, right? And I struggle with whether the amortizing or spreading, whether spreading is meant to be redundant of amortizing, or whether, as Your Honor says, and I mean, frankly, Your Honor, so I argue that spreading is there to be synonymous with amortizing. But would I die on that point? No. But the Texas law does require spreading using the actuarial method, and that is what the jurisprudence preceding that law did. That's what the jurisprudence subsequent to that law did.
But we have to do something with the fact that amortizing is in there too.
Yes, Your Honor, and I struggle with that as well, right? So what I've done is I've looked at the body of case law, the very fine, distinguished courts over a period of 20, 25 odd years, subordinates to this court have all engaged in the same analysis as the analysis engaged in by the very fine district court, which decided this issue provisionally, because it didn't ever reach the issue of Oregon law, sending it to the Fifth Circuit and sending it here.
So if we use amortize or spread, whichever one we use, do you disagree that the actuarial method as it's commonly understood is to apply a payment first to outstanding interest and then to principal, right? And then compute interest on that remaining principal balance? So
Your Honor, I'm glad you asked me that because you asked something important of my friend a couple minutes ago. My friend said early on, with respect to the definition of actuarial method, you can get it on your cell phone, you can look it up. And when I was preparing for this argument, I looked at the briefing, and no one had ever looked up actuarial method on the cell phone. But actually, what they hadn't looked up, and what I typed in on Friday into Google, and like my friend, I encourage you to do the same. I typed in, how do you spread using the actuarial method? And what I got was an answer that was in line with my position. And I'll read.
So your position, though, is that interest can continue to accrue on amounts of the outstanding loan that have been repaid? Is that consistent with how most people think of calculating principal and interest over the life of a loan?
Yes,
I
Your- yes, Your
understand
Honor.
that was the Texas way of doing things before the statute changed,
Yes, Your Honor.
for computing usurious interest in any event. But was the statute intended to bring us more in line with what is commonly understood, which is that you don't owe interest on a principal amount that's been repaid?
So, Your Honor, in the 1980s, there was an explosion of loans that were no longer the simple kind of loans that Nat'l's dealt with, right? There was variable interest rate loans. Okay, that comes in the 1980s, and there are two things that I think are important with respect to the backdrop of interpreting this law. And then I'll get to what my cell phone told me, right? Two things are the explosion of variable interest rate loans and all kinds of ways of messing with interest rates. No interest down the first year, 30% the second and third years. That's the first thing. The second, I spoke with such certainty, but now I'm losing
Well, can I just ask you, just as trying to concretize this,
Yeah.
if I took out a $1 million loan for 10 years, and I pay back all but $1,000 of it within the first year, how much interest can be charged to me in years 2 through 10 without violating the usury statute?
And Your Honor,
$280,000 each year?
well, so Your Honor's getting another problem. What about a loan? So the Texas law, the Texas test seems to be designed so that you can evaluate whether a loan is usurious on the day it's entered into. You don't actually have to wait until it's been fully paid. And the answer that you get using spreading according to the actuarial method is the same whether you apply to the test before any interest payments have been made or after the loan has been completely satisfied. What you're raising, Your Honor, is that in the test that's been advocated by my friend, there are many circumstances where you actually don't know whether a loan is usurious at its outset. You only know at the conclusion based on whether.
Well, isn't that what 306.004B is about? It's to say, look, if at the conclusion it's paid off, you just make sure, and if it turns out that because of these creative ways of structuring debt that you've paid too much, well, to avoid usury, you just credit whatever it would be to keep it. But it doesn't say, I think, that the actuarial method, we can just ignore those words and go back to something like Nat'l. So again, what's the answer to my question? What's the amount of interest that would not be usurious, the maximum you could charge me in years 2 through 10 under your theory?
So again, and Your Honor, saying what the actuarial method requires doesn't really get you very far with respect to the statute.
But
Saying
if in
what
combination
spreading,
with your loan agreement that required principal payments, I think that's the difference, right? Yes, there will be times when you won't know because a consumer or a person may make additional principal payments on the loan, and you wouldn't know that at the outset. But here, didn't the loan agreement require payments that included an element of principal, thus requiring a declining principal balance during the life of the loan?
and what Your Honors seem to be advocating for is usury as a trap for the unwary, whereas all prior Texas precedent.
No, that's the point, is that in the former case, you wouldn't know and potentially couldn't be usurious. But if you've required, as part of the loan agreement, if you've required principal payments, then oughtn't those be taken into consideration under the actuarial method?
So my reading of spreading according to the actuarial method is that when you have variable interest rates, when you have rates that are tied to the rate of inflation, that on day 1, day 100, day 200, day 300, they can be different. If you have a variable interest rate that's 20% above the inflation rate in October, November of 2022, then you may be at a 29% rate and you're above the rate. If you have the same rate in 1979, when you have a 13% inflation rate, then you're going to go above the rate for usury. I think the statute is constructed because it acknowledges that with variable interest rate loans having suddenly burst onto the scene in the 1980s, you have circumstances where over a period of, say, 10 years, with a very, very risky borrower, which is what we have here, you're going to have circumstances where inflation may kick the rate up above the usurious rate. But merely because 1 year a loan turns out to be usurious does not mean that over the 10-year life it is usurious. That is the purpose of the statute. That is the purpose of spreading using the actuarial method.
But that doesn't require charging any interest on principal that has been paid. Because I agree with what you just said. At least it sounds plausible enough to me. But I don't think that that's the position the district court took. I think the district court was taking something that was, and again, let me try one last time. In my hypothetical, which I don't think is that complicated, what is the maximum amount? $1 million, I pay all but $1,000 off in the first year. It's a 10-year loan. What is the amount of interest that I can be charged in years 2 through 10 consistent with the usury statute, under your theory?
And I'm bad at math, but it's 28% per
So
year.
200, is it 28% of the 1,000 or 28% of the million?
So under Texas law, it's 28% of $1 million.
Under your understanding of Texas law, it's 28%, it's 280,000, so I've got $1,000 remaining for 9 years. Now, I get that only a fool would do that, but that's your theory, is that it would not be usurious to charge me $280,000 under Texas law, despite this statute referring to spreading or amortization using the actuarial method because of Nat'l's, which was an interest-only loan secured by real property?
Correct. And
now, is there any part of this country you've criticized your friend on the other side for looking to out-of-state sources describing what actuarial method meant? Is there anything that you have found in which, in any other state, any other authority, actuarial method is used to support that result?
So when I look up how do you spread using the actuarial method, what I get is a circumstance where you are evaluating. I'll read you what I got, Your Honor. I got spreading using the actuarial method refers to distributing the cost of future liabilities, like pension benefits, evenly across an individual's working life by calculating the present value of those future obligations and allocating them proportionally over their expected employment period, essentially smoothing out the cost over time using actuarial calculations based on factors like age, salary, and mortality rates. This ensures a more consistent funding level for the plan through the employee's career.
Are we asking AI to answer the certified question?
No, but I'm taking up the invitation of my friend to look it up on the cell phone. I'm telling you what I get when I look it up on my cell phone. I get something where we're not referring to amortizing. I get something where we're referring to taking a whole chunk of variable figures, in this case interest rates, and smoothing them out across. Recognizing in the case of very, very high-risk loans that have variable interest rates, which may be tied to inflation or some other metric, you are going to get circumstances. You're going to get years where you may exceed the level of usury. But if over the time of the loan you don't exceed the level of usury, then the loan is not usurious.
So I take your point on that, but it sounds like spreading and amortizing may be doing different things. Like you're using them both, but so to your point, if the interest rate is 2% in year one and 20% in year two, and it changes all over, you're going to average that out, and that's spreading. I understand that, but the amortizing seems to be doing something different. So that's with the rate, but the amortizing seems to be with respect to the principal and how much of the principal is left that rate is being charged on, which is a different question. And that seems to be the question that the Fifth Circuit is asking us to address, not do you spread the principal out over the whole, but it's how do you figure out what is the base that amount is being charged on. And it seems like if you look at the Truth in Lending Act definition and some of the other definitions, what they're saying is regardless of what the loan terms actually say, so regardless of Justice Young's example, if he chooses to prepay principal and therefore doesn't owe any more interest, even though the loan doesn't require him to do that, we don't have to worry about that because all we're doing is calculating the maximum that could possibly be charged. And then the question would be, well, how do you calculate that? And it seems like the answer is, regardless of what the loan documents say, you credit any amount that's required to be paid first to interest and then to principal. Do you agree with that?
I don't agree with that.
Why?
Well, so Your Honor, and this goes back to Your Honor's first question to me, which is how do I treat amortizing or spreading? It doesn't say amortizing and spreading. The legislature said amortizing or spreading. I think
as the case may be, depending on which part of the calculation you're looking at.
Well, I mean, as Your Honor points out, if it's amortizing or spreading, and the legislature is giving you two different alternatives, you end up in a world of chaos and tears. But if you look at it as the Kennan Court looked at it, in that the legislature meant to codify the Supreme Court, your court's decision in 1937, then spreading is defining what amortizing is.
What
Amortizing or spreading. Yes, Your Honor.
You touched on something I wanted to ask you about in terms of the text. The previous version did say amortizing and spreading. The current one says or, as you correctly point out. But what does your position make of what I take as the critical change in the amendment to remove in equal parts
Okay.
and substitute using the actuarial method? What's the meaning of that amendment?
So I take that.
What's the effect of it?
So I take the effect to be a recognition that in equal parts was redundant of the word spreading. The word spreading, as Texas had applied the law for some 60 years prior to the 1997 amendment, and then 62 years prior to the 1999, that was that point.
So does that leave using the actuarial method to do any work at all?
It does, because it's spreading using the actuarial method. And spreading, and I apologize, in some ways it's a simple case, I'm just repeating myself, but spreading using the actuarial method is taking a degree of varying inputs, a degree of varying interest rates, or what have you. And the case, the law is also sensitive to the point that there may be things of disguised interest, right? There may be. And so you throw all that into the big pot, and that is what is spread using the actuarial method. Much as when you're calculating pension issues, you take everything in the future into account, and you spread that out to avoid lumpiness, the lumpiness that can come when a business has to suddenly confront some sort of logjam. Instead, you spread it out. I hope that answers your question.
So the old statute called for us to engage in amortizing, prorating, allocating, and spreading in equal parts during the period of the full stated term of the loan. Now, after the late 1990s amendment, it calls for amortizing or spreading using the actuarial method during the stated term of the loan. How does your reading give any effect to the change that was made in the 1990s there? Like we're supposed to assume, perhaps it's a legal fiction, that our friends in a different branch meant to do something by changing the wording here. And so what work would this new language with or going in and actuarial method going in and I guess prorating and allocating coming out, what did the legislature accomplish by making that change if it doesn't change the outcome in this case?
So the legislature, when you're reading four different gerunds, the verbs in gerund form, to your Honor's point, I don't know your names, I apologize, I'm from Philadelphia. But to your Honor's point, when you have four different options of what you do, it's just utter chaos. I really do think the legislature was taking away the ands and putting in an or, and by reducing the number of terms from 4 down to 2, and by honing in on spreading, which is what this court in 1937 did, that the legislature meant to simplify and harmonize with this court's precedent from 1937.
But even you acknowledge it's not quite that simple because we're not sure what to do with amortizing. And I wonder if you think it's reasonable to interpret amortizing or spreading to be referring to the terms of the loan agreement and what it requires.
Could you ask? Sorry, could you ask it slightly differently?
Is it reasonable to take the language of the statute and assume that it means you have to apply the actuarial method to determine the proper amount of interest or the max amount of interest, but that the terms of the loan agreement may control whether you amortize? You amortize using the actuarial method or you spread using the actuarial method.
So My best answer to Your Honor is that two answers. First, all the case law to date is really in our corner, is really in Appellee's corner. And I'll tell you why I think it's that way. I think, one, because I think we have the legitimate reading of the statute. But two, I also think that as a practical matter, when you introduce ands, you introduce a great deal of uncertainty into a really weird area of the law. And the beauty of the Neville's, sometimes simple is actually better. Sometimes straightforward is actually better. The beauty of the Neville's test is that you do have something simple. And you don't require an expert in every single case. And people, when they make these contracts, when they make these loans, they should know what they're bargaining for. They know what the law is going to be. What my friend is advocating for is a system where there's a great deal of uncertainty, and there is an expert required, and every single loan you have to look under the hood. And loans are vastly complicated, and judges always do their best, but we're not all mathematicians. Lawyers are not all mathematicians. So the Neville's test is fantastic in that regard. I think I'm out of my time, but.
Chief, could I ask one? I wanted to see if you wanted to respond to the questions I had about the Oregon choice of law, and although I suggested that I'm troubled by that, the Fifth Circuit says on page 17 of its certifying opinion that this question is determinative of the usury claim. So should we just assume that the Fifth Circuit has taken care of that, and this is not our problem? They say it's determinative. They must at least implicitly have chosen Texas law, or how would you advise us to look at that?
So I will echo what my friend said when he was asked that question by Your Honor, which is that the threshold question in the district court was whether Texas law applied, or what Texas law was. But even if, honestly, Your Honors, even if you do make a determination with respect to what the statute means and it gets kicked downstairs, there will be briefing with respect to whether, in the district court, with respect to whether this actually is a contract where Oregon law applies, because the contract says Oregon law applies, or whether the state of Texas will override the agreement of the parties.
You think the district court would still have the authority after the Fifth Circuit says that this is a determinative question for this case, whether Texas law reaches this result, that you think the district court is still open to the district court to say, no, it turns out it's Oregon all along?
Well, so that was the question of whether it was Oregon all along was briefed, but the district court specifically reserved decision with respect to.
And the question is whether the Fifth Circuit reserved its decision or whether it's essentially resolved. That's the question I'm trying to figure out.
And that was not, that was not briefed.
Okay,
the Oregon law was not briefed before the Fifth Circuit, so I think that would have to be heard by the district court.
Got it.
Any further questions? Thank you, Mr. Kessler. Mr. Catanzaro, I believe you have 5 minutes.
Okay, a couple of points. First of all, Neville's is interest only. So my friend's suggestion that Neville's is some brilliant, not that it's not brilliant as a Supreme Court decision, but that it determines this case is inapplicable, because this case involves amortization of principal and interest over a 3.5-year term at, we would point out, 34.5% interest in excess of the usury limitation on a commercial loan entered into in 2018, which is precisely why we're here. With respect to whether or not it's Oregon or Texas law, we believe that Texas law applies and will apply to this transaction, and that Oregon law will be rejected for a whole host of reasons. It's an important issue, and that's why the district court took up and said, well, maybe it doesn't make a difference because of the calculation I'm going to do. He was wrong. Respectfully, he was wrong, and we took the matter up.
Do you agree that Oregon law would not take into consideration a declining principal balance in determining the maximum allowable interest rate? That's correct under Oregon law?
Yeah, Oregon law basically has no limitations if it's a commercial loan over $50,000. $50,000.
So it's not really focused on the calculation. It's just freedom of contract, no usury in a commercial context.
May well be,
okay.
Yes, may well be. And for that reason, we hardly dispute that it would apply in this case for a Texas company negotiating a loan and concluding a loan in Texas with a Texas partner, including with a Texas partner.
What's the typical remedy for a successful usury allegation? Is it reduction to the maximum interest that would be non-usurious, or is it some more punitive remedy?
Well, the Texas usury statute provides for all manner of penalties, including giving up all interest, and could be treble damages and the like. So it's got a big bite to it, the statute. So, and particularly if we are correct, which we believe we are, on the bargain purchase side of which added substantially to the amount of additional interest that would apply to the loan. So this is an important question. And let me say that this is an important question for all of Texas, because the usury statute, if you apply this, quote, Neville's rule, whatever it is, from 1937, when we didn't even have calculators, as I argued in the Fifth Circuit, I told them we would have to do it on pen and paper to determine what the interest rate was. There's no case that in Texas that actually addresses how do you do the calculation when you're paying an amount that is in excess of the interest rate. You can apply it to the principal, and the method of that application is something that we ask you to determine.
And you're going to share how we do that math? I think you'd said you might show us somewhere where it is in the record, or show us how you think that, on your reading of the statute, the math ought to have been done.
Well, it's as was suggested. It's you apply it first to the interest component for that 1 month. The difference, because of the payment, the difference is applied to principal. You calculate interest again, apply the loan.
But
so
you said there was some sort of exhibit that was attached to something or other in the record, and you were going to give us a
yes,
site for that.
And it's at the record at 514 to 515 is our schedule. It's Exhibit G. It's our schedule of calculating what the principal and interest amortized would be, and the calculation under the loan. The actual loan schedule is attached as an exhibit to the promissory note in that same complaint, First Amendment complaint. So they're both there to compare. The distinction being that, talking about the Sinclair anticipating, shall we say, gaming the system to avoid a calculation, a charge of usury, the principal and interest schedule in this note, as you'll see, doesn't say what the interest rate is.
But it was known in advance in this case. Like, if you looked at this when you went into it, you would be able to tell that it was going to be usurious. Is that correct? Or were there circumstances that made it that way later?
Well, you would have to input the numbers and do the calculation on an Excel spreadsheet, because
Well, it's 42 months. It's not that hard, right? You have to look at it. We're talking about a lot of money here. And I guess what I'm asking is, it would be knowable relatively quickly that this amount was going to be a lot higher than 28% of all of the principal at the time.
Well, in order to, I wouldn't say, my brain wouldn't work that fast. Maybe yours does.
Oh, we're talking about huge amounts of money and the penalties and all that kind of stuff. It's not that hard before you enter into a massive transaction like this, where the total amount of interest, you could see looking at it, wow, that's actually a lot more than the principal. I wonder what the effective interest rate is. That's a calculable thing at the beginning, whereas there are some circumstances, I think your friend was talking about, in which, based upon prepayments or it's variable and all this kind of stuff, you wouldn't really know that going into it. But this transaction, it was set in stone at the beginning, correct?
It was.
And so I guess, your answer to the Chief Justice's question, the troubling thing about that is, this is just a wonderful thing to enter into a usurious contract. Okay, well, let's enter this contract, fantastic. At the end, we'll be able to show that it's far greater than 28%. We won't have to pay any of the interest. We'll get treble damages, attorney's fees. This is just wonderful. That's a great deal if you can get somebody to propose to you something at the outset that is just on its face usurious, right?
You're reversing this.
I'd like that deal, I think.
You're reversing the Sinclair comments that somehow the borrower who was the victimized becomes the winner and successor. Well, I mean, if it were so easy, we wouldn't be standing before the Supreme Court arguing.
Well, is that what 306.004B is about? Is to say, look, before you can say that it's usurious, you have a shot at squaring it up. Is that part of the answer? What do you think 306.004B does?
Well, yeah, I think there could be that, yes. I think they could come to their senses and refund all the money that they'd have to refund and pay all the attorney's fees. They won't do that, though.
Yeah.
Any further questions? Thank you, Mr. Catanzarite. Thank you to both counsel. Thank you. The case is submitted, and that concludes the argument set for today. The marshal will adjourn the court.
All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.
Good to see you, my friend.